Before ending this talk, I'd like to cover one or two additional points, things that are worth thinking about during the process, which don't come neatly into any one stage in the procedure. The first thing I'd like to mention is the possible risk areas when you're devising selection criteria, the possible risk that you may inadvertently be discriminating against certain members of staff. So obviously you need to make sure that the selection criteria you adopt do not have the effect of inadvertently shutting out particular groups of employees. And the most common example you can find is where you have a disabled employee. You may want to mark people based on their attendance at work, for example, and you may find that that disabled employee has a worse attendance record because of their disability. Now, in that situation, you'd be expected as an employee to flex the selection criteria in order that you don't unduly disadvantage disabled members of staff. You may also need to think about making adjustments to the way you communicate the news about redundancy and the way you conduct the consultation meetings, for example, to cope with people with mobility problems. And also you need to be aware that they may well be people who are potentially at risk of redundancy who are not actually at work at all. And the most obvious example is someone on maternity leave. You may also have staff on long-term sick leave. Those people need to be consulted in just the same way as all the other members of staff, and you will be in difficulties if you fail to do that. Another point to note in relation to people on maternity leave is that where you are considering alternative employment, if you're lucky enough to have alternative jobs, people on maternity leave are entitled to go to the top of the queue. That's a little known feature, and it's one of the few examples in our domestic legislation where positive discrimination is allowed. So that's just a pitfall to be aware of. But for the remainder of the time, I just want to talk about ways in which an employer may wish to help employees facing redundancy, and particularly employees working their redundancy notice. It's a difficult time. How can an employer make things a little bit better? Well, the first thing to consider is that you should, in fact you're legally obliged to allow employees time off to look for alternative work. That has to be paid subject to a cap of 40% of the week's pay. Most employers ignore that and just give people as much time off as they need. The other thing that you can look at is paying for careers advice or help writing CVs and that kind of thing. It's rather grandly called outplacement counselling. That is something that if you provide that benefit, it doesn't get taxed. Most benefits you provide to employees, even a cup of tea in the morning, taxed on the value of the benefit to the employee, but this is a tax break to encourage employees to help their staff in this way. And certainly larger employers will bring in consultants when they do a big redundancy program. The other thing, of course, to think about is whether you've got anything in the budget to pay people over and above their legal entitlement. Obviously that goes down very well. There is also a tax break for that, because broadly speaking, the rules are slightly complicated, but if you make a payment when you're terminating someone's employment, isn't a contractual payment, in other words, it's something you're not legally obliged to provide, that will be tax-free up to £30,000. From that £30,000 is deducted the amount of any statutory redundancy payment. So you need to work that out. But that is something that many employers will consider doing. Which leads me to the final topic of today, which is whether or not an employer should ask an employee to sign a settlement agreement before parting with money. Normally that isn't the case in a simple redundancy program where you're simply providing the statutory redundancy payment. If you're parting with significant amounts of money, then many employers will wish to make sure that when they've got their money, the employees won't also bring a claim in the tribunal to challenge the process. Now, you can't legally sign away your rights to unfair dismissal, redundancy, any other statutory rights, without entering into a formal agreement with the employer. That used to be called a compromise agreement. It's now known as a settlement agreement since last year. And there are two elements that need to be satisfied. Firstly, the wording in the agreement needs to be expressed in a particular way, so the employee is completely clear about what he or she is giving up. And secondly, the employee is required to get independent legal advice on what they're doing, and that advice is normally paid for by the employer. So there are pros and cons to settlement agreements. Obviously the pro is that the employer knows once the redundancy process is finished that they won't be facing claims in the employment tribunal. The disadvantage is that it does tend to lengthen the process, and it also costs more. So there's a balancing exercise, and then generally speaking, the more generous the compensation package that an employee receives, the more tempted an employer is going to be to require the employee to sign a settlement agreement.